8:53 a.m. on July 29, 2025. This is a special docket today of the Oil Conservation Division. We have approximately 23 cases on the docket today. We did have a trailing contested hearing docket, but they have all been resolved to my understanding, and we don't have any contested cases at this time. So we're going to be hearing some cases by affidavit, and our UIC group has asked me if we could hear two cases out of order. So whoever is representing FAE, you're going to be going first. These are cases 25220 and 25221. They are docket cases 7 and 8 on the worksheet. Entries of appearance, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of FAE2 Operating.
Morning.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Oxy, and we are just monitoring.
Morning. Are those the only parties that you know of, Ms. Hardy?
I believe so. ConocoPhillips entered in it. Did you enter?
Carrie Halley on behalf of ConocoPhillips entering her appearance in this case. Thank you.
Thank you.
I believe those are all the parties.
Please proceed.
Thank you. In case number 25220, FAE seeks an order approving statutory unitization of its Lamunian unit and also expanding the vertical limits of the Teague Paddock Blindbury pool to include the Teague Glorietta Upper Paddock SW pool within the unit area. The proposed Lamunian unit comprises approximately 3,960 acres of federal and fee lands located in Township 23 South, Range 37 East in Lee County. The unitized interval extends from the top of the Glorietta Formation to the base of the Blindbury. Our exhibit packet includes the self-affirmed statements of Joseph Kent, the Director of Land, Charles Hooper, Geology, and Vanessa Neal, an engineer. Each witness has previously testified before the division and been recognized as an expert in their respective fields. Mr. Kent provides the plats and ownership interests, C-108, notice information, the BLM preliminary approval letter, unit agreement, unit operating agreement, and ratification agreements that have been signed. Mr. Hooper provides well logs, a structure map, cross sections, water sample report, a map of fresh and produced water sample locations, and a pool map. Ms. Neal provides a feasibility study, seismicity assessment, and economic projections. Exhibit D includes the affidavit of publication, and notice was timely published on February 23rd of 2025. So with that, I would ask that the exhibits be admitted into the record. And I don't know, Mr. Examiner, if you'd like me to go ahead and present the next case as well, the companion case, and then have the witnesses available for questions, or what?
Let me find out from our technical examiner. Do we have Mr. Harris and Mr. Getz with us?
Yes, good morning.
Good morning, Mr. Harris.
Yes.
Would you state and spell your name for the record, please?
Yeah, my name is Tony Harris, Tony, Harris, Harris.
Thank you. And is Mr. Getz with you as well?
He should be joining us shortly, I would think.
Okay, all right. Okay, Mr. Harris, do you want these cases presented sequentially, or do you want them presented at the same time?
I guess we could do them at the same time.
Okay, Ms. Hardy.
Okay, thank you. In case 25221, FAE seeks an order approving an enhanced oil recovery project, secondary and tertiary recovery in the Lamunian unit area by the injection of water and gas into the Glorietta, Paddock, and Blindbury formations. FAE proposes to convert 8 producing wells to injectors within the unit. The proposed average injection pressure is expected to be approximately 950 PSIs. The maximum pressure will be calculated relative to the depth of the highest perforation using a factor of 0.2 PSIs per foot, and then could be increased based on a step rate test. The maximum daily injection rate will be 800 barrels of water per day, or as permitted by the division. FAE seeks authorization to include additional injection wells within the project administratively. FAE also requests that the enhanced oil recovery project be qualified for the recovered oil tax rate. Our exhibit packet includes the self-affirmed statements of Charles Hooper, Geology, and Vanessa Neal, engineering. Again, both of those witnesses have previously testified and been recognized as experts. Ms. Neal provides the Form C-108, production history, incremental production and economic summary of the unit, and incremental production and economic summary of the wells. Mr. Hooper provides well logs, a structure map, cross sections, water sample report, map of fresh and produced water sample locations, and a feasibility report. Exhibit C includes the notice information. Notice was sent to the parties on March 11th of 2025 and was published on February 23rd of 2025. With that, I request that these exhibits be admitted into the record as well, and our witnesses are available for questions. They were filed a couple of months ago, actually. Yes. April 8th, 2025.
And Ms. Vance, we have a withdrawal of objection.
That's correct.
You also have a hearing statement.
Yes, we filed it just to be on the safe side, but I don't have any questions for her witnesses.
I have found the exhibit packet in 25220. It is 1,518 pages. Is that the most updated packet?
It is.
All right. And I don't hear any objections to the exhibit, so they're admitted in this case, and I'm not looking at the other case, but there have been no objections to the exhibits in that case, so they're admitted without objection. Now, do you have your three witnesses available?
I believe they are available. I see Mr. Kent there on his video.
Mm-hmm.
I believe they're all in the same.
Yeah, we're all in the same room here, Mr. Hearing Examiner.
Okay, I can see two people. Is there oh, there we go. Okay, very good. Would you all raise your right hands, please? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, let's start with Miss Neal. Would you state and spell your name?
Yes, it's Vanessa Neal, VANESSANEAL.
Okay, thank you. And Mr. Hooper,
Yes.
state and spell your name?
CHAR, Charles Hooper, CHARLESHOOPER.
Thank you. And Mr. Kent?
Joseph Kent, JOSEPHKENT.
All right. And Mr. Kent, you've been previously admitted as an expert before this division?
Yes, sir.
In what field?
Landman.
Okay. Miss Neal, same question?
Reservoir engineering.
Perfect. And Mr. Hooper?
Geoscience.
Okay, perfect. All right. Mr. Harris, do you have questions for the witnesses?
Yes, I do.
Okay, who do you want to address first?
I guess we can maybe do it as a panel because I'm not sure who's
Perfect.
best to answer, but
Okay.
first questions in regard
Hold on,
to
Mr.
exhibit
Harris,
pack-
hold on one second. I got to get an
Okay.
okay from the attorney. Miss Hardy, is it okay that Mr. Harris asks the question to the panel and whoever is most suited will ask?
Absolutely, yes.
All right, thank you. Mr. Harris, go ahead.
Okay, thank you. So I'm referring to exhibit pack, which for case 25220, 1,518 pages. If we could go to page 123 of 1518, please.
Let me share my screen here.
Yes, that's it. Thank you. So this is your initial plan of development summary, but if you scroll down to the bottom of the page, it shows that it's only page 2 of 32. And then beyond that, it goes to a completely different section. So it appears to be missing information here. Do you have the plan of development, and was it included in the application?
We do have a full detailed plan of development that is usually required from the BLM that we provide to them annually, but I believe we only included the summary of it, which is what was page 2 of that full development in this application.
Okay, is that something you could provide after this hearing? for us to
Absolutely.
review? Okay.
Mhm.
Thank you. If we could now go to page 753, please.
Mr. Harris, your microphone isn't picking you up clearly. And
Okay.
for the witnesses, Ms. Neal, you answered that last question, but from now on, since it is a panel, if you're going to answer the question, please state your name and then answer the question.
Yes, sir.
Okay, can you hear me now?
Yes, perfectly.
Okay. Could we go to page 753, please?
Is this the correct page that I've pulled up?
Yes. The primary approval letter by the BLM, it notes that Exhibit B was not approved, and that the corrected Exhibit B needed to be submitted. Has that been submitted?
This is Joe Kent. Yeah, yes, it has. And that I think that was saying that it would be prior to final approval that a updated Exhibit B would be submitted before they would grant their final approval. So this was their pre-approval. They were requesting changes to the format of the Exhibit B, and that those changes would be submitted and approved before they would be able to grant their final approval. And the final approval will not occur until after we receive the NMOCD approval.
Okay, so just to clarify, so has Exhibit B been provided to BLM?
Yes, a draft preliminary Exhibit B has been provided to the BLM as of today, yes.
Okay. And is it included, so as of today only, so it's not included in the exhibit package we have, is that correct?
No, it is included in the exhibit package we have as well.
Okay, could you show me which page that's located on, please?
Yes, let me scroll through here. It's going to be the unit agreement, which is in Exhibit A, labeled as Exhibit A10.
Do I have the correct document pulled up, Mr. Kent?
Yeah, that is correct. So it's going to be the Exhibit B to this unit agreement, is what he's referring to in that letter. The schedule of ownership. Yeah. So scroll down a little bit more, Dana.
Just trying to find it since there are a lot of
Yeah.
a lot of pages in these exhibits. I don't want to.
It's going to be, no, it's going to be down more.
Further?
Yeah, it's going to be, Exhibit A is going to be the plat. So basically, as soon as you see the plat, it's going to be the next exhibit after that.
After the unit okay.
Okay, for the purpose here, so it's safe to say that it is included in the exhibit pack that OCD does have, the one we're looking at right now, that the schedule of ownership is up to date.
Yes. Yes, it is.
Okay. That's fine. We can move on. I'm not sure if Mr. Getz has joined us, if he has any questions regarding 25220 before we move on.
I will let you continue and I will pop in once you're done. Thank you.
Okay, thank you. If we could move to case 25221, which is 434 pages. And do we have the exhibit pack for that case from, I think it was submitted on April 8th?
Yes, I'm just pulling that up.
Okay, thank you.
Mhm.
Okay, if we could just go to page 5, please. Okay. So at the very first sentence there, it says that the injection pressure could potentially be increased to 0.65 psi per foot, which would equate to 3,200 psi. Could you please elaborate on what is the current reservoir pressure, or do you have an estimate of current reservoir pressure?
This is Vanessa Neal. We could calculate it, but I do not remember off the top of my head what the current reservoir pressure would be. Getting it up to 3,000 or PSI would only be after approval of a step rate test and increasing the injection pressure to that much. We expect the initial injection pressure to be at most 1,200 pounds.
Okay. All right. And do you have an estimate for the original reservoir pressure? And would you be over avoiding and exceeding the original reservoir pressure, or what would the plan be for that?
No, 1,200 would not be exceeding the initial reservoir pressure.
But
Again, I don't want to misspeak. Yes,
sorry to
1,200
interrupt. Is
surface.
1,200 psi the surface pressure or the actual reservoir pressure?
The surface pressure.
Surface. Okay. Thank you. We have some questions regarding the wells within the area of review, and in particular, some items specific to the sealing off of strata. So if we could go to page 75, please. Okay, so when we look at this well, if you look at the well file for this particular well, the 10856, we have, if you could just scroll down a little bit more, please. So below the intermediate casing string there, in the center of the page, you see we have an open annulus from, I think it runs from approximately 3,000 feet down to approximately 5,100 feet approximately. And if we look at the formation tops for that particular well, we have the Queen and the San Andres and the Glorieta. Those are completely exposed and open, so none of that strata has been sealed or isolated. And this well is in close proximity to some of the proposed injection wells. So we just want to bear this in mind, keep this in mind as we proceed forward, please. But the basic point here, the context, is that we do have an open annular section with the Queen, San Andres, and Glorieta exposed and not sealed and isolated. If we could move to page 74, please. Or sorry, 76. Okay, similarly, if we scroll down, we have open hole here again we have internal plugs on the inside of the casing, but outside, just below the intermediate casing, from approximately 2,950 feet, where those perfs were squeezed, down to approximately 5,600 feet. Again, we have open annulus with the Queen, San Andres, and Glorieta formations not being sealed and isolated. Carrying on with this theme, if we could go to page 81, please. And if we could scroll down some more, please. Okay, thank you. So again, here it appears that we have open hole section from approximately 3,695 feet down to the top of cement for the 7-inch, which was at 7,410 feet. So again, we have Queen, San Andres, and Glorieta formations in pressure communication, though that strata has not been sealed off. And this could lead to potential communication pathways during injection operations. And finally, one more well to look at is page 96 of 434. So again, this is a well where, as they were drilling the open hole section, or sorry, as they were drilling the below the intermediate casing shoe, the intermediate casing collapsed, I think, at 1,900 feet. And so you can see below the intermediate casing shoe, we have open hole well bore with, I believe there's a fish drill pipe inside the tubing, or sorry, inside the well bore. And so there's everything from the Seven Rivers, Queen, Grayburg, all the way down to the Devonian that's exposed in this well bore. So again, a communication pathway and strata is not effectively sealed off. So I guess from just to point the clarification here, going forward, OCD would need to evaluate and would want to see some remediation in these wells to seal off the strata to prevent cross flow from San Andres, Glorieta, and other formations, to prevent cross flow and to seal that strata such that the San Andres is not in communication with the Glorieta, Blindery, Drinkard, the requested units for this water flood. Is that clear? Do you have any questions on that?
That's clear. We understand.
Okay, thank you. If we could go to page 124, please. We could just scroll down a little bit so we could see the x-axis. Okay. If we look at the time period from around 1992, between 1992 and 1996, perhaps, we see that there's an uplift in production here. If we look at the green squares, you see that there's a production increase because the green dots are clearly showing an uplift in production, along with an increase in water production from the blue squares and an increase in gas from the red squares. Of particular interest here is that if you look at the black line on the bottom, there was no new wells drilled during this period of time. So can you please explain or elaborate on what you think may have caused this production uplift when there was no new wells drilled?
Sure. This is Vanessa Neal again. In the mid-1990s, there was a recompletion program and later a infill program where they added and fracked the lower paddock and additional pay within the Blindberry. And that was what caused the uplift in production during that time period.
Okay. Do you think any of that uplift could have been as a result of cross flow from San Andres and intervals above the Blindery?
No, I wouldn't think so. They did very targeted recompletions during that time. And it was specific lobes, upper lobes within the Blindberry and the very lower paddock, which was not open on any of the examples that you just showed.
Okay. Did you collect do you have any water samples that would confirm that it's reservoir water from the reservoir itself and not from disposal uphole?
We did do compatibility tests and collected samples from the producing wells. And they showed, I mean, the ones that we had showed it was Limeberry water predominantly.
All right, thank you. If we could go to page 125, please. So the legend in this table, up top right-hand corner, I think. Yeah, so is this plot, if you look at the top right corner, it says for secondary operations. Just want to confirm that this is the production profile. When I view secondary, I look at that as water flood versus CO2 would be a tertiary flood operation. So from that perspective, is this plot here only for secondary operations, i.e. for water flood operations?
Yes.
Okay, thank you. If we could go to page 150, please. In, I think paragraph 5, and I'm sorry, paragraph 11, it does state here that the injection fluids will be contained to the injection interval as a result of stratigraphic containment above and below the injection zone. So while that may be a valid statement, considering the open annular sections we just looked at in the 4 wells, do you still support that statement? I think this was a statement from Mr. Hooper.
Yes, this is Charles Hooper. Geologically speaking, we believe there to be in the lower St. Andrews zone a sufficient seal to keep the water injected into the Glorietta Paddock Limeberry formations contained within the Glorietta Paddock and Limeberry formations. As a result of those 4 wells that you listed with the open, or I guess the casing without cement behind it and zones above that, I can't speak with confidence without looking at those further and evaluating.
Okay, thank you. So this statement would be specific to the stratigraphy alone.
Yes.
Okay, thank you. If we could move to page 169, please. Okay, so this is part of your development plan, your EOR feasibility study. Your first statement there, the first conclusion, is that based upon analog field results, the unit can be successfully water flooded. So I think, is it safe to say that you're relying 100% on the performance of analog fields for your assessment of this field, or has there been any independent reservoir simulation done?
This is Vanessa Neal. No, we're not relying 100% just on analog fields. There was actually a core study done 10 or 20 years ago, taken from wells specifically from this field. And they analyzed the water flood and CO2 properties in that core study and proved it to be feasible.
Okay. So I guess in terms of for your analog field relative to your Lemunyon unit, I mean, is it similar depositional environment and similar reservoir quality, or what are you looking at here?
Yes, it was other Blindberry paddock floods in the local area. Specifically the Nidu, Ebdu, Webdu, the Justice unit. Trying to think, I think there was one more, but I can't remember what it was.
Okay. And were those anticlinal structures similar to the Lemunion unit?
The Justice unit was the Nidu, Ebdu, Webdu is not an anticlinal structure.
Okay. And so those structures or those analogs, were they all 5-spot patterns, or was there a line drive, or what was the flood mechanism?
There was a mixture in different areas. Generally, most of them did 5-spot patterns. There were specific areas in the Nidu, Ebdu, Webdu where they did closer down spacing down to 5 acre well spacing. But I believe they maintained a 5-spot pattern while doing that.
Okay. All right, thank you. Sis, if we could go to page 171, please. So it states here that section 1.2, the lower Platic and the Blindberry are the primary targets for secondary recovery. And then the north side have an additional upper Paddock and Glorietta potential. If we look at a case file 12756 that was filed by Arch Minerals several years ago, in that particular case file and the subsequent order that was issued, there was a water flood project on the same anticlinal structure and in the same interval in the existing pool, but they didn't include the Glorietta as part of that water flood. So has there been any changes in your assessment from then versus now as to why FAE is including the Glorietta?
Yes, a couple of years ago in 2021, we tested the Glorietta in this field on a couple of different wells in a few key locations. And based on of that, we'd like to include it with this water flood in the unitizing.
And that was Miss Neal who was speaking.
Yes, sorry.
Okay, thank you. Just a couple of more questions. On page 176, thank you. Section 2.6 below. Maybe it's 2.3, but it mentions in here a gas oil contact and an oil water contact. So based on that terminology, this reservoir was initially a saturated reservoir with a free gas lake.
This is Charles Hooper. What we're illustrating here is that the GOR cutoff for our cum oil and gas figures fall within the oil well classification as defined by the OCD as less than 100,000 cubic feet per barrel. In terms of a gas oil contact, no, we do not have a mapped gas oil contact in this reservoir. And likewise for oil water contact, we don't have due mostly to availability of wells. We don't have a well-defined oil water contact, but we do have a lowest known oil, which is how we kind of drew our unit outline and defined our productive reservoir limits.
Okay. So then, actually, it was section 2.6 on page 178 that I was referring to. We go scroll down just a little bit more. Yeah, so it's the original oil in place. Mapping was performed by reducing the Glorietta, Paddock, and Blimbury net reservoir maps to net pay, defined as the oil-bearing reservoir between the gas oil and oil water contact. So you're saying that there is no mapped gas oil contact?
That would be, that's a definition of a net pay. It probably should have been better worded. That yes, we don't have a drawn out gas oil contact within this reservoir. All zones that we've tested have been oil productive.
Okay. So, and the context here is just understanding what was the original conditions of the reservoir. Were you dealing with a saturated reservoir with a gas oil contact or on a free gas cap, or was it undersaturated whereby there was no free gas? And just wondering, how does that factor into your depletion plan here, in terms of what sort of increase in reservoir pressure you would be targeting under secondary recovery operations?
And this is Charles Super again. In terms of, we don't believe there to have been a free gas cap in the northern part of the field at the top of the structure. We still don't see, gas only zones, even at the very top of the the vertical limits. We see oil production. Now, locally, it is possible to have a higher gas saturation as wells have drawn down pressure, and you might have had, you might have reached bubble point locally in well spots, but we don't see, gas wells here. We see oil wells. And in terms of the increase in pressure, I don't have a concept off the top of my head, a number off the top of my head for what would need to be increased to see the response. Did that answer your question?
Indirectly, perhaps, yeah.
Okay.
Just from the context of reservoir energy, and if you're going into a secondary recovery operation, I was just curious as to where you would be in terms of what your target would be for maintaining reservoir pressure versus the original reservoir pressure. Because on another page, on page 179, you mentioned that your original formation volume factor, your B sub O, was 1.3 reservoir barrels per stock tank barrel. And just curious where the reservoir sits now relative to that formation volume factor, because if your reservoir has been depleted, that formation volume factor is going to be much lower. And if without knowing that value, the volume of water that you're injecting could be overvoiding the reservoir and pushing oil down dip and out into adjacent blocks and adjacent units. That's the context I was looking for. But that's fine. The information is not available. We'll move on. That concludes my questions. I can hand it over to Mr. Getz.
Mr. Getz?
Thank you very much. Good morning, all. Just have 3 items. First is a question for Mr. Hooper.
Yes, sir.
And your self-affirmed statement on the hydrology and items associated with your water sampling. And if you really need a reference, it's page 1099 of 1518. And I believe it is 25220, exhibit for that. Exhibit B6 was the water samples. Anyhow, in general, we make the statement that we will not have any hydraulic or communication with shallow groundwater. Did we make any effort to isolate or at least identify what is the source of groundwater as far as this Dockham, Santa Rosa? Is this what we're looking at?
Apologies, let me pull that back up. Yeah, so this is Charles Hooper. In terms of the freshwater samples, I do not know that we specifically listed a formation that these were coming from, but I believe them to all be shallow wells.
Okay. I'm going to ask you to do a little more clarification in writing. This is not
Sure.
really good, proper hydrology. And since underground sources of drinking water is a critical item, at least let's give these things a name. At least when looking at one of the wells, we have a capacity of 43 GPM per minute. And the water sample that you took from it is very low in TDS. So let's get a clarification statement on what you think the aquifers you are protecting, whether they're alluvium, whether they're Dockham, whether they're anything you can be familiar of, and we can associate and say, okay, we've identified it. So I would ask for that. Thank
Yes,
you.
sir.
Second item, induced seismicity. This is just a general statement. I would not write off totally the relationship with water floods, especially for the West Dollarhide. It was identified by Dr. Alan Sanford when he did the seismological assessment for the website. It has also been brought to our attention. We'll be meeting actually with the Bureau of Economic Geology, University of Austin, as a part of the scissors. And that's for the record, I never quite get this right, is a Center for Injection and Seismicity Research. We're doing a lot of effort out there on the platform, so we will keep you informed of that situation. But there is no blanket statement anymore that shallow injection on the large scale of a lot of these projects does not have a relationship to induced seismicity. So just wanted to keep you informed of that. And we may be asking for additional information on operations should we need this to support research in this area. So that's my second item. My third item is to Ms. Hardy. For case 25220, we have tried to put in the expansion of the vertical limits and pools. I would recommend and strongly suggest, and probably you'll see this in the order, is that you go ahead and provide a separate case like we've done for your other FAE projects. And we will go and request that this be done as a separate case so that we can track it as a nomenclature and a change or expansion or contraction of a pool so that we can keep track of these things as we do on our pool maps. To that end, I believe that we're going to arrange a meeting with Mr. Kent, and you may come along and we will talk about this and others, but I will request to the examiner that this item, we will separate it out in the hearing order. And at that point, move forward as a separate case. Otherwise, I have no other additional comments. Thank you.
Understood. Thank you.
Any redirect?
No, thank you.
All right. Do you have Ms. Hardy, do you have a list of the additional requests from Mr. Harris and Mr. Getz?
I believe I do. If I could restate that to make sure I understand. I think it's, the first one is the complete plan of development. And the second,
Is there an exhibit number to that?
it's currently a summary and it's in case 25220, I believe it's an exhibit B.
Exhibit B is in boy?
It's part of that exhibit.
Okay, all right.
Yes, so we can submit the complete plan of development. And then the second request involved the water samples and additional descriptions. And Mr. Hooper, do you have an understanding of exactly what the examiners are looking for on that?
Yes, I do.
Okay,
Which exhibit is that, Mr. Hooper?
That is in the C108. It's in both cases. And it is exhibit B. Six.
Thank you.
okay, and then on induced seismicity, I understood from Mr. Getz that that was something that would just be monitored.
That is correct. We would,
Okay.
we'd be communicating with you, but just to make you forewarned, the situation may change as we get more research in. Thank you.
And then I understand that we are requested to work with OCD to file a separate application on expansion of the pool. So I think the only two pieces of information were the plan of development and the water sample information.
So, Mr. Harris, Mr. Getz, how do you want to move forward with this case? Do you want that evidence submitted and then come back on the record for continued review, or how do you want to work this?
At this point, I think since it's not contested, I think we'd be willing to go ahead and take it under advisement.
Okay,
With a time period specified for the submittal of the two items that we requested.
okay. Ms. Hardy, how long do you think it'll take to submit that?
Mr. Hooper, Ms. Neal, how long do you believe it will take to obtain the information?
This is Charles Hooper. I think by the end of this week.
This is Vanessa Neal. I agree. The plan of development is already done, so it'll just be gathering up the statement clarification on the freshwater zone wells.
So should we set a deadline for close of business August 1st?
That's fine, thank you.
Yes. Sorry.
Yes.
Okay, Mr. Getz, Mr. Harris, close of business August 1st work for you?
Yes, it does.
All
Yes,
right.
sir, it does.
We'll leave the record open till 5 p.m. August 1st, and then this case will be taken under advisement as long as we get the information we need. Now, can you submit a revised exhibit packet for both cases that includes this information with a cover letter?
Yes.
All right, thank you. Okay, all right. So, Mr. Harris, Mr. Getz, there will only be one revised exhibit packet for you guys to look at.
Okay.
Anything further?
Just one point before we leave, if I could.
Go ahead, Mr. Harris.
Yeah, one thing in review of this application, obviously it's for just a couple of components here. It's the secondary recovery, which is water flood, and then there's a request for tertiary recovery, which would be CO2 flood. At this time, based upon our initial review, and I'll let Mr. Getz elaborate if necessary, but we could support, obviously, with remediation of those wells that we discussed with the open annulus. We would be able to support a secondary recovery operation through water flood. However, a tertiary water flood would be a bit of a stretch at this point in time, and would probably have to come before a separate hearing. Considering the age of the wells and the energized nature and corrosive nature of the CO2, that would take much more in-depth investigation, I think. So at this point in time, suffice to say, secondary recovery with water flood, we are willing to evaluate and entertain, but the tertiary would be an additional step. I'll let Mr. Getz elaborate on that if necessary.
Well, I don't need to elaborate. Mr. Harris has done quite well. Thank you.
Is there
Ms.
any
Hardy.
questions on that?
All right, thank you, Mr. Harris. Ms. Hardy, anything further?
Thank you.
No, thank you.
All right, so we are off the record on these two cases. Let's proceed to the rest of our docket. All right, let's start out with Avant Operating LLC, case number 24849. And let's see if it's joined with any other case here. No, I don't think it is. Entries, please.
Thank you, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating. Coterra Energy Operating acquired Avant's interests in this acreage and the acreage that's subject to this case in mid-January. And so when the division asked for Avant to continue the case, I did file a continuance, but on behalf of Coterra Energy Operating as a successor in interest.
Okay, thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador, and we are just preserving rights. So no objections.
Thank you. The division, so this case was originally heard in January 2025. And it's my understanding that the division, well, let me just say that at the hearing, I noted, and Mr. McClure and I had a discussion about the fact that there was a party that had not received notice of the hearing. And that party had not received mailed notice, but had received actual notice of the hearing. Avant's landman contacted it, the interest owner is MVDR. And Avant's landman had contacted MVDR once we realized there had been some confusion about the title in this area, and reached out to them via phone and email and made them aware of the hearing, and also made them aware that Avant was not going to seek to pool them at that hearing due to the defect in notice. And MVDR agreed with that approach, that so long as Avant did not seek to pool MVDR, MVDR would not object for lack of notice. So there was actual notice of the hearing. And that was the day before the hearing or 2 days before the hearing. And they had actual notice of their right to object, and they did not because they were not being pooled. So we had the hearing, and we discussed this issue, and it was my understanding after the hearing, in fact, the hearing record indicates that the case was taken under advisement. And then in the ensuing months, I understand that the OCD has been reconsidering whether under the rules, notice is required to parties who have not yet committed to a unit, but who are not being pooled. And it's my understanding that perhaps the division has come to a conclusion that those types of parties are entitled to notice of a hearing, even if they're not being pooled. So that's why we're here today, is to discuss that. And I understand from Mr. McClure to discuss the status of the outreach to MVDR. And I do have a witness available, but before we turn to him, I just thought I could maybe short circuit the process and say that Coterra has been in discussions with MVDR. There is not a JOA yet in place, but they are working towards obtaining a JOA. And so if the division is inclined to require that notice be given to working interest owners who are not being pooled, we would ask that the division that I be allowed to continue the case to August 21st. I would send MVDR a notice letter, and then they would be able to appear at the August 21st. And I chose August 21st because that's a contested hearing date, a special docket date. And that's enough time for me to actually get the notice letter out under the division's rules. And so then we would be able to perfect notice, which I think is to the extent that notice is required, which I'm happy to discuss that further if there's room for discussion, but to the extent the division has determined that notice is required, I would ask that I be allowed to continue the case to August 21st, perfect notice, and if MVDR wants to object, they can come to the hearing at that time, or perhaps by then we will have a JOA in place.
Perfect, thank you. I'm just communicating with Mr. McClure and waiting for an answer for him. So thank you for the presentation and clarification. All right, I don't believe Mr. McClure has any questions for your witness.
Thank you.
I think that your proposal is suitable. So what will you do? So you're going to continue the case to August 21st. We'll hear it in the beginning of the docket to make it easy. And what will you do in the meantime with MVDR?
So first, the case will be continued only for purposes to cure notice. So no need to go through all the evidence again. And in the meantime, and what's already occurring is Coterra is in discussions with MVDR in the hopes of entering into a JOA before August 21st. But if Coterra is not able to enter into a JOA with MVDR by August 21st, and if MVDR does not appear at the hearing, then the division can move forward with entering the order, just as in the usual course when any party gets a notice letter and does not object to the hearing moving forward.
So are you going to have a piece of evidence for the division to consider that would be the notice to
Yeah.
MVDR?
Yes, I will
Okay.
submit a short exhibit packet that will include the notice letter to MVDR. And of course, if MVDR enters into a JOA between now and August 21st, I would submit a short motion to the division asking the division to vacate or to not require us to come to hearing on August 21st.
That sounds good. What would be the deadline for your notice exhibit?
The deadline for filing the notice exhibit or the deadline for me sending out the notice?
You sending out?
It would be August 1st or July 31st.
So 20 days before.
Yes.
20 working days
Mhm.
before. If they're-
20 calendar days.
Okay, great. Mr. McClure, does that work for you?
I almost wonder if we shouldn't continue to August 21st regardless, so we can review the notice and put it on record that way. Only speaking towards the concept that if they sign the jail in the meantime, I wonder if we shouldn't have opportunity to review that and continue regardless.
Well, if they sign a JOA and we get something from Ms. Bennett that says we have a JOA in place with MVDR, I believe her statement should be enough for us to not need a hearing or to bring the case back on the 21st of August. I think that, she has a duty to be candid with the tribunal under the ethics. Is there anything further, Ms. Bennett?
Nothing on that particular point, but as we've been sitting here, I did recall that in our exhibit packet that we filed, we did not pool MVDR. So if we were to approach the August 21st hearing and MVDR had not signed a JOA and Coterra needed to move forward with pooling MVDR, in that situation, I would need to file an amended exhibit packet as well. I'm hoping that all of that will become moot, but I did just, as we've been sitting here, that did occur to me. And I appreciate Mr. McClure's desire to have some, I guess, certainty on August 21st. And I'm not necessarily opposed to continuing the case to August 21st, even if, I would do that today, no matter what. So if that's the concern, I would do the continuance today, no matter what, file it. And if, at the end of the day, the division determines that they would still like me to come back on August 21st to confirm that there's been a JOA, I'm happy to do that. I don't see the need for that. We don't typically have to confirm that a party's entered into a JOA, but I'm happy to do that.
So, Mr. McClure, if you're willing to I think it's a proper suggestion from Ms. Bennett that if they do put a JOA in place, before August 21st, that an email from her would be enough for me to change the status of the case to take it under advisement without having additional evidence on that point. But if you feel strongly about that, then we'll come back no matter what.
Mr. Hearing Examiner, it's not so much about not trusting the attorney to be candid. It's a matter of reviewing what they submit to us, similar to like when we have an error on the CPAC. We want to make sure exactly what's submitted and have that opportunity to review it before we preemptively say it's going to be taken under advisement with the record left open. I guess I don't know what your thought process is as far as that goes. I guess it's just my recommendation that even if it's only reopening it and talking about it for 30 seconds, you know, on the next docket, it seems like that might be the most aligned, I guess, with how we're approaching all the other cases as well.
So we need evidence. I think what Mr. McClure, what you're saying is we need evidence of either the notice to allow MVDR to object if there is no JOA, or if there is a JOA, then we need evidence that there has been a settlement there. Is that what you're saying?
Yes, that's correct, Mr. Hearing Examiner.
And normally, how do you, Ms. Bennett, how do you normally provide evidence of a JOA?
In the exhibit packet that we submit, there would be a committed versus uncommitted. And I haven't looked back at the Sapphire exhibit packet to see if my recollection is that we put an asterisk beside MVDR and said that they were not yet, that we were in discussions, or Avant was in discussions with MVDR. So we could submit an affidavit from Mr. Robertson that shows that there has been a JOA, and we could submit amended exhibits that show that MVDR is in the committed column versus in the uncommitted or asterisk column.
Okay. So Mr. McClure, if Ms. Bennett provides an affidavit, a revised exhibit packet with an affidavit from the landman saying we now have a JOA, would that alleviate bringing the case back on August 21st?
Well, I was going to say that would cure the issue with whether notice was provided per the requirements under rule. I guess I'm not understanding how that would necessarily preclude the need to review what's submitted, though. Having said that, I mean, at your discretion, if you want to take it under advisement with record left open, then we can proceed that way. If
Okay.
you'd like.
Okay. All right, Ms. Bennett, I think what Mr. McClure is getting at is that he'd like a chance to review the evidence. And if there are any questions, to be able to be on the record, have your witness available. So please continue the case August 21st. Good luck with your JOA negotiations, and we'll revisit the case then.
Thank you.
Thank you very much. We're off the record in that case. Let's go to number 2 on our docket. Let me find it. That case number is 25350 COG operating, and let me see if it's no. Entry of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant COG. And we are just here. I'm hoping this takes all of 2 seconds for you. We had a Scrivener error, and that has been corrected. And I believe you can see it on page. Let me get there. Oops, I just had it up.
Yes, we have it.
Okay, page 5.
We have it, Ms. Vance, and the case will be taken under advisement. Thank you.
Excellent. Thank you.
Thank you. We're off the record in that case. Moving on to number 3 on our docket. This is EOG Resources 25433.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant EOG. And in this case, we just provided a revised chronology of contacts. We just included a little bit more detail, and that was filed, I think, the same day as the hearing that we presented at last month. So with that, I would ask
Are you moving anything into evidence?
the revised hearing packet, yes.
Okay, without objection. Mr. McClure, any questions?
No questions, Mr. Hearing Examiner.
We'll take the case under advisement. Thank you, Ms.
Excellent.
Vance.
Thank you.
Let's move to number 4 on the docket. This is Spur Energy LLC. It is 25447.
Yes, good morning, Jackie McLean with Hardy McLean on behalf of Spur Energy Partners.
Good morning.
And I believe there are other entries.
Good morning, Mr. Examiner. Jacob Everhart, that's Everhart,
Thank you.
with Beatty Wozniak, New Mexico, on behalf of Riley Permian Operating, entering our appearance for monitoring purposes only.
Thank you.
I think those are the only ones. And in this case, this one had an issue with the exhibits being reviewed in time. So we do have to present the entire case.
Go ahead.
Okay. In case number 25447, Spur seeks an order pulling all uncommitted interest in the San Andreas Formation, underlying a 160-acre, more or less, standard horizontal spacing unit comprised of the north half, south half of Section 25, Township 17 South, Range 27 East in Eddy County. And Spur will dedicate this to the Black Cherry Federal Com 110H well. The exhibits that were submitted by Spur for this case includes the land testimony and corresponding exhibits of Colleen Bradley, as well as geology testimony exhibits of Matthew Van Wee, both of who have been previously admitted to testify as experts before the division. We also have notice testimony and exhibits that show the notice letter was timely sent back on June 17th and publication was made on June 21st. And unless there are questions, I ask that the exhibits be admitted for case number 25447 and the case be taken under advisement.
Mr. Everett? Who has signified no. So without objection, exhibits are admitted. Mr. McClure?
No questions, Mr. Hearing Examiner.
The case is taken under advisement. Thank you, Ms. McLean.
Thank you.
Moving to number 5, also Spur Energy Partners, 25453.
Yes, and Jackie McLean on behalf of Spur Energy Partners.
Jacob Everhart, on behalf of Riley Permian Operating, entering our appearance only for monitoring.
I think EOG is also entered, but
I don't know who represents EOG. You know?
probably just Miss Kessler. Miss Kessler, I think.
Okay, I don't see Ms. Kessler here. Ms. Kessler, are you with us? Right ahead, Ms.
Okay, thank you. For this one, at the last hearing, Mr. McClure asked that we submit 2 C102s for the well because it is in 2 pools. Spur did submit the amended exhibit packet to include a new exhibit A2 on July 27th. And so I would ask that these exhibits be admitted into the record and that the case be taken under advisement.
No objection from Riley.
Okay, without objection. Mr. McClure, I see a note here about exhibit C2.
Yeah, that's correct, Mr. Hearing Examiner. The applicant was asked to correct a issue with their notice spreadsheet. They failed to do so. However, we do have verbal testimony from them in regards to when written notice was provided. So assuming that we're good with using that verbal testimony, then we should be fine to take the case under advisement.
We are definitely good with taking that testimony as evidence unless there is conflicting evidence in the exhibits.
Mr. Hearing Examiner, there's not conflicting evidence within the exhibits. One of the first column was duplicated into the second column. So it's not that there's conflicting information. It's just the information was mistakenly not provided.
Perfect. So Ms. McLean will take this case under advisement. Thank you.
Thank you.
Let's move on to number 6. This is Spur Energy Partners. Ms. McLean, is this your case too?
Correct.
All right,
Yes.
it is 25454.
Thank you. In this case, we do need to present the entire case.
Right ahead.
In case number 25454, Spur seeks an order pulling all uncommitted interests in the San Andres Formation underlying a 160-acre, more or less, standard horizontal spacing unit comprised of the north half, south half of Section 29, Township 17 South, Range 28 East in Eddy County. And this unit will be dedicated to the Smithdale C Federal Com 110H well. We submitted exhibits from Ms. Bradley and Mr. Van Wee for Land and Geology, who have been previously admitted to testify as experts before the division. And we have the notice testimony exhibits that show that notice was timely sent on June 18th and publication was made June 21st. With that, I ask that the exhibits be admitted for case number 25454 and that the case be taken under advisement.
Thank you. Without objection.
Mr.
Were there any-
Gambler, you didn't call for entries of appearance in the case.
That's what I was about to ask. Were there any other parties that had objected to this? Did you object?
No, we did not object, but I wanted to note the entry of Longfellow Energy Partners LP to preserve their rights in case they want to pursue de novo.
Okay, perfect.
Likewise, Mr. Hearing Examiner, on behalf of Riley Permian Operating, just monitoring purposes only, no objections.
Had Riley objected at one point?
No, sir.
Ms. McLean, why was this case on this docket? I thought this was just for contested cases.
This one was also the exhibits weren't reviewed in time for the July 10th hearing.
I see.
So that's why we're here.
Okay, perfect. So your exhibits are admitted.
Thank you.
Mr. McClure, any questions for the witnesses?
No questions, Mr. Hearing Examiner.
This case is taken under advisement. Let's
Thank
move to
you.
Number 7, 25220 FA. Oh, no, we've done 7 and 8 already. Let's move on to number 9. This is COG Operating 25440.
Good morning, Mr. Examiner. Michael Felderwerk with Santa Fe Office of Holland and Hart on behalf of the applicant. And I believe you're going to hear these with cases 25441, 25442, and 25443.
So I'm calling those cases as well.
And Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Devon Energy Production. And no objection.
Had you objected?
These cases, initially Devon had filed competing applications and Paloma also had competing applications, but those two sets have been dismissed. So no objection at this point.
Perfect, thank you.
Mr. Examiner, these cases involve the continued development of the Bone Spring Formation and the initiation of development of under the Wolfcamp Formation under sections 20 and 29 and 23 South, 34 East down there in Lee County. The Bone Spring cases 25440 and 25440 and 25441. First off, there are current Bone Spring spacing units in these sections, so we are seeking approval of the overlapping spacing units. There's also an ownership depth severance in the Bone Spring Formation. That's why 25440 pools above the base of the first Bone Spring, and 25441 pools below the base of the first Bone Spring. And we also have, in those cases, approval of a non-standard 1,280 acre spacing unit for efficient development of 2-mile wells. This will allow efficient well spacing, avoid unnecessary NSLs, and reduce the surface use. The Wolfcamp cases, which is 25442 and 25443, are more straightforward. They seek approval of standard 640 acre horizontal spacing units for 2-mile stand-up wells using proximity tract wells. What you'll see from this case is that we filed an amended set of exhibits this week to supply the Form C-102s. Unfortunately, we're still waiting on the pool and the pool codes for these particular wells. So we're going to have to supplement when those pool and pool codes become available, unless Mr. McClure can tell us today what they are. Other than that, our exhibit packets are all basically the same. They contain the self-affirmed statement of Michael Monju, who's a landman who's previously testified, and he goes through all of the sub-exhibits that he's provided. Then we have the self-affirmed statement of Ben Brayman, who's a geologist who has also previously testified before this division, and he provides both the standard exhibits for the Bone Spring Formation and the Wolfcamp Formation. And then in each packet is our Exhibit C and Exhibit D, which is our self-affirmed statement of notice, and then the affidavit of publication. So we would ask that these exhibits be admitted, recognizing that we're going to need to supplement the C-102s to provide the pool and pool code.
Okay, thank you. So your exhibits in all four cases are admitted into evidence without objection. When it comes to your letters, when were they sent out?
So if you look at Exhibit C, the letters were sent out on June 20th.
That timely?
Yeah.
All right.
And then
your
our notice of publication was back in June as well.
Okay, perfect. Thank you. All right. Are your witnesses available?
Yes, sir.
Okay. Mr. McClure?
Mr. Examiner, I do have questions for the landman.
Okay, can we get the landman on screen?
That would be Michael Manju.
Ah, you're in person.
See, you're in person.
Would you have a seat and turn on the microphones, the button on the right? Thank you. Would you raise your right hand, please? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Would you state and spell your name for the record?
Michael Manju, M-O-N-J-U.
Okay, and Mr. Felderwert announced that you had been previously qualified as an expert by this division in what field?
In land.
Land.
Yes.
Okay. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Monshu, I'm looking at Exhibit A-3, specifically the summary of track ownership in the amended exhibit packet for case 25440. This is on page.
Mr. McClure, give a sec for Mr. Felderwert to bring up the exhibit on the screen, because the witness doesn't have it.
Mr. McClure, which case was that?
I'm looking at case 25440, and that's page 43 of 88 in the amended exhibit packet.
Okay, give me 1 minute. Share. And which page are you, sir?
Specifically, I'm on page 43. To be fair, the same question kind of applies across all the different cases, but
Okay. I believe I have it up now.
yes, sir. Mr. Monshu, do you see what Mr. Felderwert is sharing?
I do.
Okay, on that track ownership, this for the track 1, for instance, where you have the totals of 0.25. Please confirm for me that this is a percentage of the whole unit. Is that correct? How that's laid out?
That's correct.
Okay, thank you. Mr. Feldward, if you can scroll down just a little bit to the yellow highlighted parties at the bottom in the totals. Mr. Monshu, if you could just confirm for me, those highlighted parties there, that's depicting which persons the applicant's requesting the division to force pool. Is that correct?
Correct.
Okay. Let me scroll down my notes through the other 3 cases real fast. Thank you, Mr. Monshu. Mr. Hearing Examiner, I have no further questions, but I do have some requests for Mr. Felderwert.
Okay. Do you want to tell him by case number what you need?
Yeah, I mean, it slightly deviates between the cases, so that may be the most ideal for sure.
Okay, and before you do that, Mr. Folderworth, do you have any redirect for this witness?
I do not.
All
Thank
right,
you.
thank you, sir. Thanks for your appearance. Sure. Mr. McClure, go right ahead.
Hey, Mr. Felderwort, I'm looking at case 25440.
Okay.
In this particular case, there's actually two different Bone Spring pools. Let me actually bring up the case file right there.
Well, no wonder we couldn't figure this out.
Yeah, there's like a hearing order that established a pool. Well, regardless, in section 20, the pool code is 2209. This is the Antelope Ridge Bone Spring West. I think it may be the one you actually have included currently. Yeah, this is the one you have included currently. However, in section 29, the correct pool is pool code 5130, and that's the Bell Lake Bone Spring.
So then when we file our supplement to the hearing package, we'll file two C-102s for each spacing unit, allocating out the acreage to each pool.
Exactly so. And then on the CPAC, we'll just need to include both pools in that column, pool name and pool code.
Oh, I got you on a compulsory pooling checklist.
Yes, sir, that's correct.
Okay.
In addition to that, for this case, you have the formation name or vertical extent. That's at the top of that formation pool category in the compulsory pooling administrative checklist. You see where I'm referring to, Mr. Felderwort?
Run that by me again.
Oh, the formation name or vertical extent.
Okay.
It's just a couple fields above where the pool name and pool code is.
Yeah.
In this case, you have it listed as the Upper Bone Spring Formation. You see what I'm referring to?
Yeah, which made sense to me.
Well, unfortunately, it's incorrect. The Upper Bone Spring Pool is from the top, or excuse me, the Upper Bone Spring Formation is from the top of the Bone Spring to the top of the first Bone Spring sand. So that extent that you have listed there does not include everything you're asking to, or that the applicant is asking to be force pooled. So we'll need to correct that to ideally just say Bone Spring Formation, but just anything that represents both the Bone Spring 1 and the Avalon.
Oh, I see. So you're saying that terminology, I have it up now. Upper Bone Spring Formation does not include the Avalon?
The Upper Bone Spring Formation does not include the first Bone Spring.
Okay.
It includes just the Avalon.
So to make it simple, should I just put Bone Spring Formation?
That would probably be the easiest solution.
Will do. Okay.
And that's everything for that case. Moving on to case 25441. This has the same pool issue that we just referred to in regards to the section 20 versus section 29. Do you want me to rehash it, or are you good with your notes, Mr. Felder?
I got it.
Okay, very good. Yeah, that's just the exact same corrections on this one. So there's nothing further on 25441 versus what was in 25440. Moving on to case 25442. There's an incorrect pool listed here. Let me bring up the case file to get you the correct pool. Okay, the correct pool for this is a Wildcat Wolf Camp. A lot of numbers and letters. I'm not going to speak it out, but the pool code is 97965.
So if I go to the division's website and go put in the pool code, it'll have the Wildcat pool terminology.
Yeah, that was quite literally, I guess, what my question was going to be, because I will spell it out, but
You don't need
if
to.
you're familiar with that process you just laid out, then that might be the easiest way.
Agree.
Okay, very good. And in this particular case, we're just going to need to amend the CPAC, the compulsory pooling administrative checklist, to include the correct pool, and then the amended Form C-102s.
Certainly.
Okay, moving on to case 25443. It has the same pool issues as 25442. Are you fine with your notes, Ms. Felder, or do you want me to rehash them out?
I'm fine with my notes. Thank you.
Okay, sounds good. There's just one additional thing here. I don't know if it's an issue with the PDF that was uploaded, but it appears to be missing your signature on the CPAC. So when you resubmit that, if you could just make sure to include that.
Got it.
Okay, thank you, Mr. Felderworth. Thank you, Mr. Hearing Examiner. I have nothing further for these 4 cases.
So do you want to bring these back to review the information in the future?
To be consistent with how we've started doing it, that would be the ideal path.
When is the next docket that we can put these on? August 7th?
Are you asking me, Mr.
I
Hearing
am.
Examiner?
I am, yes.
Yeah. I think we should be able to do it on August 7th. I don't think that'll
Okay.
be a big deal.
All right. Freya, do we have room August 7th?
We do.
Excellent. Mr. Felder, would you continue these to August 7th so we can wrap them up?
I will certainly do that.
All
Thank
right,
you.
thank you. Mr. Felder, anything further on these 4 cases?
No, sir.
All right, thank you, sir. Moving on to case 13, this is Admiral Permian Operating 25335. And let me see if it's in, yes, 25336. Entries, please.
Yes, good morning, Jackie McLean on behalf of Admiral.
Thank you.
Mr.
Oh, and
Examiner,
so-
Jim Bruce on behalf of MRC Permian Company.
Thank you, sir. Did you withdraw your objection?
Yes,
All right, thank
of
you.
record.
And we're also representing COG operating Concho Oil and Gas and COG production in these cases as well.
You're representing COG and Admiral.
Correct.
Perfect.
Yes.
Thank you. You want to proceed?
Yes, thank you. In these cases, Admiral seeks to pull the Bone Spring and Wolfcamp formations in sections 5 and 6, Township 24 South, Range 27 East in Eddy County. And Admiral will dedicate these spacing units to the War Pigeon fed calm wells. With its Bone Spring application, case number 25335, Admiral seeks approval of a non-standard spacing unit, while the Wolfcamp application, 25336, is a standard proximity tract spacing unit. The exhibits that were submitted by Admiral for these cases include the land testimony and corresponding exhibits of Hunter Hall, who has previously testified before the division and has been accepted as an expert in petroleum land matters. We've also included the geology testimony exhibits of Jared Haynes Hammett. And Mr. Hammett has not previously testified before the division. We've included a copy of his resume, and I asked that he be admitted as an expert in petroleum geology.
Can we bring him on the camera?
I saw his name on there earlier.
Yeah, it's available. Hello. There we go. Okay, it's a little hard to see you, I guess, because of the bright background. Maybe it's causing your face to be dark. I can see you better now. Thank you. All right, would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, would you spell your name, please?
Jared Hammett, Jared, Hammett, Hammett.
And which field are you seeking to be qualified before this division as an expert in?
Petroleum geology.
Geology. Okay. What education do you have going to that expertise?
I have a BS from West Texas A&M University and a master's from the University of Houston.
And when did you achieve those?
2003 and 2009.
Perfect. Okay. And what work have you done? What experience do you have in that field?
I worked since 2003 for a variety of oil and gas companies, including Anadarko Petroleum, Plantation Petroleum, Admiral Prairie Resources.
Can you give me a little more to go on?
I've done a variety of work in geoscience related to oil and gas, mapped all fields, correlated well logs, secret stratigraphy work, core descriptions, development plans, operational geology, asset evaluations, and a variety of other tasks.
And who do you work for now?
Admiral Permian Resources,
Okay. And what is your title?
Geoscience Manager.
You're science manager. Okay. And what are your duties now?
Oversee all operational geology, geosteering, well operations on the geoscience side, as well as all development planning for new horizontal and unconventional developments. We also screen and evaluate properties and evaluate acquisitions and divestitures, as well as do all types of subsurface mapping.
All right. Thank you, Mr. Hammer. That's sufficient information for the division to recognize you as an expert in petroleum geology from here on in. Okay, Ms. McLean, you were.
Yes, thank you. Finally, we have the notice, testimony, and exhibits that show that the notice letter was sent back in April, and the affidavit of publication was for April 22nd, 2025. Happy to answer any questions that we might have, and I ask that the exhibits be admitted for case numbers 25335 and 25336, and that the cases be taken under advisement.
All right, thank you. Mr. Bruce?
No questions.
You mean no objections?
No objection.
Thank you, Mr. Bruce. Okay, without objection, Ms. McLean and Mr. McClure, any questions for the witnesses?
I have questions for the landman, Mr. Hearing Examiner.
Well, thank you, Mr. Hammett. Can we get the landman on the screen?
Yes, Mr. Hall.
I'm here.
I see you. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Please spell your name.
Hunter Hall, HUNTER HALL.
And you've been previously recognized as an expert before this division?
I have.
In what field?
Petroleum land matters.
Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Hall, if I can direct your attention to your exhibit A-3, specifically in case 25335. This is on page 31 of 81.
Okay, I'm there.
Okay, do you see under track 1 where you have Matador Resource Company / Federal Abstract Company?
I do.
Can you describe for me the relationship between Matador Resource Company and Federal Abstract Company?
Yes, this the interest under the federal lease that is listed, Federal Abstract Company bid on behalf of Matador in the February lease sale. Subsequently won the tract, and I and Mr. Bruce may have understanding of this further, but I'm unsure if the transfer of operating rights has been done to Matador yet, but they bid, Federal Abstract Company bid on behalf of Matador. So we listed both with the understanding of that.
Okay, so then is it correct to say that they're not the same entity? You're just not sure who is in possession or is the owner, I guess, of this working interest. Is that correct?
Yes, that is correct. My understanding currently is that the Fed has not processed the transfer of operating yet. operating rights yet, but it has been submitted. So that's the current status.
Okay, so then is it accurate to say that the applicant, Admiral in this case, is requesting the division to force pull the working interest in track 1, be that either Matador Resource Company or Federal Abstract Company?
That is correct, and both parties have been noticed appropriately, to my knowledge. Mr. McClure, are you there?
Mr. Hall, yeah,
Sorry, I was just making sure we didn't skip out.
no, I'm still here, Mr. Hall. I'm just reviewing my notes. Mr. Hearing Examiner, I have no further questions for either of these cases, but I am going to have a request for one of the cases.
Which case?
That would be for case 25335.
25335. Okay, so does that mean we can take 25336 under advisement?
With the testimony that we just received, yes, we can take 25336 under advisement.
All right, perfect. Okay, 25335. What do you need?
Ms. McLean, on exhibit B5, this should be the cross section that in the geology exhibits.
I'm heading there right now.
Is there a page number, Mr. McClure?
For some reason in my notes, I did not include a page
Looks
number.
like page 53 of 81 of the exhibit packet.
That is correct, Ms. McLean. On this exhibit, we are missing the well name, number, and API number for each of those logs that's depicted. Do you see where I'm referring to?
Yes, I do.
If I were to request for this exhibit to be for this exhibit packet resubmit it with this amended to include those three things, do you understand what I'm asking for?
Yes, sir.
Okay. I have nothing further, Mr. Hearing Examiner.
All right, thank you, Mr. McClure. So, Ms. McLean, would you continue this case to August 7th so we can conclude it?
Yes, we'll do.
All right, perfect. Okay, so we are off the record in those two cases. Let's move on to number 15 on our docket. Number 15 is joined with other cases. These are Matador Production Company's 25247 and 48, 50, 52, 53, and 54. Entries, please.
Morning. Good morning, Mr. Examiner. Michael Felderwart, Santa Fe Office of Holland and Hart, appearing on behalf of the applicant MRC Permian Company.
All right, thank you.
Good morning, Mr. Hearing Examiner. Good morning, Technical Examiner. Darren Savage with Abby and Schill, appearing on behalf of Alpha Energy Partners 2 LLC.
Mr. Savage, did you withdraw an objection?
We did.
Okay.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of ConocoPhillips Company, as well as Marathon Oil Permian.
Thank you.
Mr. Examiner, Jim Bruce representing Mewburn Oil Company.
Mr. Bruce, did you withdraw your objection?
Yes, sir.
Thank you. I think that's all.
I think so too. Mr. Examiner, these cases involve the development of the Bone Spring and Wolf Camp formations under sections 27, 28, and 29 of Township 22 South, 28 East, and Eddy County. The company seeks to pool spacing units for proposed 3-mile horizontal wells. The Bone Spring spacing units are 480-acre laydown units, and then the Wolf Camp spacing units are 960-acre laydown units because they're within the Purple Sage and gas pool subject to the special pool rules. We filed separate hearing packets in all 6 of these cases. The only issue that I discovered was that the working interest owners and the track maps, there was some discrepancy there. When I looked at them, they weren't matching up correctly. The company has informed me this morning that they have been now corrected. We can file them at any time. So that can be done today if you'd like, or we can refile them for a later time. Other than that, what you'll see in each of these packets is the usual information, including the self-affirmed statement of Hannah Rhodes, who's a landman with the company that's previously testified, and then the self-affirmed statement with Andrew Parker, who you are familiar with, who's a geologist with the company, who has also previously testified in a number of cases. Each of them provide the usual exhibits with their self-affirmed statements, and Mr. Parker has both the information for the Bone Spring Formation and then also for the Wolfcamp Formation in his statements. Notice went out back in April before there was a lot of contest that we've since resolved. So with that, we would ask the admission of the exhibits filed in each case. We are prepared to refile them to correct the discrepancy in the track maps and would like the matter taken under advisement at the appropriate time.
Thank you, Mr. Veldorf. So your exhibits are admitted in these 6 cases without objection. I'm going to turn to Mr. McClure. Mr. McClure, questions for the witnesses?
Yes, Mr. Hearing Examiner, I'm going to have questions for the landman.
Just the landman. All right. Well, Mr. Feldworth, I'd like to take a 5-minute break while you get your landman.
Certainly.
Screen.
Yep.
And then we'll continue.
Looks like Hannah's there, and we'll come back to her in 5 minutes.
Thank you. All right, we're back on the record. It's 10:41 a.m. Mr. Felderwart, you said your landman's name is what?
Hannah Rhodes.
Perfect. Okay, would you raise your right hand, please? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but truth?
I do.
Excellent. What is your name?
Hannah Rhodes.
Would you spell it?
Hannah, Hanna, Rhodes, Rhoades.
Okay, perfect. And you've been previously recognized as an expert by this division?
That's right.
In what field?
Land.
Mr. McClure?
Thank you, Mr. Hearing Examiner. Ms. Rhodes, it's a possibility this may fall under the corrections that you're already making, but if I can direct your attention in case 25252 to your exhibit A-3, which is the summary of interest, page 20 of 51.
Give me 1 minute, Mr. McClure, to get the right case up here. 25252.
25252. That's correct, Mr. Felderwart.
And the summary of interests.
Yes, sir.
Page 20 of 51.
Yes, sir.
I think we're there.
Yep, looks like Ms. Rhodes, are you with us with what Mr. Felderwart is sharing here?
Yes, sir.
Now, on this list, it appears that Marathon Oil Premium LLC is listed as being an uncommitted working interest owner. Is that correct?
Yes, sir.
Mr.
Am I
McClure,
back?
I think we lost you for a moment.
Yeah, but you guys can hear me now. Is that correct?
We can hear you now.
Okay, very good. Yeah, I have no idea what happened to my internet, but it appears to have been out for about 30 seconds there. Hopefully it don't happen again. Ms. Rhodes, did you hear the entirety of my question or was I interrupted?
No, sir. If you can repeat again. Sorry.
Yes, ma'am. On page 20 of 51, it appears that Marathon is listed as being an uncommitted working interest owner. Do you see where I'm referring to?
Yes, sir.
Now, if we scroll down to the next page down, page 21 of 51. Under track 1, it's listing Marathon as being a committed working interest owner. Is that an error or is Marathon committed?
So we have them committed via letter of support. With these cases, there are some tracks where Alpha and Newbern are claiming to have taken a lease where Marathon would no longer be a working interest owner under that lease. And so I've listed them. We've noticed the pre-existing working interest owners prior to Alpha and Newbern's lease, but we've included Marathon And the other is on the pooled list, just in case, that ends up not being true. So I've listed them as needing to be pooled, but we have them technically committed under letter of support.
Okay, I guess I'm not sure if I understand your answer. Are you saying that Marathon no longer owns the interest?
So in tract 3, which would be the south half of the southwest quarter of section 29, and Marathon owns in other tracts outside of this specific tract, but in this tract specifically, there's question of whether a lease has been taken by Alpha and Newburn, or if Marathon would still technically be a working interest owner under that specific lease, the pre-existing lease. So I have them listed in case that ends up not being true. There's nothing filed of record of this lease. We have just, we were warned or, made aware of this by Newburn. And so technically I just have them listed on here, but we do have Marathon as a committed owner under letter of support. I hope that makes a little bit more sense, but we're still in conversations with Marathon, Newburn, and Alpha, kind of regarding a specific tract in these leases taken now.
Ms. Rhodes, you referenced track 3, but that track appears to be missing, I guess, from this summary of interest here. Is that correct?
Yes, sir, that's correct. So I guess on the ones where we've listed Marathon, we've technically listed them as a committed working interest owner, but as a letter of support, under a letter of support, but we've listed them as an uncommitted. I think with Conoco also merging, I think we're just wanting to make sure and cover all of our bases under this letter of support, with that being signed via Marathon.
Is it accurate to say that track 3 is missing from this summary of interest and that it should be included?
No, sir, I think the track 3 would not be on this specific unit. No. It would only be in the case where it includes the south half, which would be the case of our Warrior 124.
Okay, so then your nomenclature for your tracks takes into account all of these cases rather than this specific case. Is that accurate to say?
That's accurate. Yes, sir.
Okay. Now you referenced a letter of intent as qualifying Marathon to be considered to be committed. Is that correct?
Yes, sir.
So you're considering them to be committed, and yet you're requesting the division to force pool them. Is that correct?
Right. We're considering them as committed under the letter of support. But in the event, in some tracks, specifically the south half of the southwest quarter, in case they are no longer under lease, we wanted to make sure and just mention that we've notified this party along with others that would have previously been under that specific lease.
So is it accurate to say that Marathon has not signed a JOA at this time?
That's correct.
Is it accurate to say that they may not sign a JOA in the future?
That's correct.
And yet, Ms. Rhodes, you would consider them to be committed to this unit?
Under the letter of support, yes, sir, but we are also continuing conversations with them regarding voluntary joinder further from the letter of support via joint operating agreement or some sort of different avenue, but still continuing to reach further voluntary joinder.
For each of these cases, is it accurate to say that Marathon was provided notice of this application and this case?
Yes, sir.
Okay, thank you, Ms. Rhodes. If I can now direct your attention, well, I guess one page further down, page 22 of 51. It appears to be a list of overriding royalty interest owners that the applicant's requesting the division to force pool.
Yes, sir.
Is it accurate to say that this is a list of overriding royalty interest owners that the applicant's requesting the division to force pool?
Yes, sir.
Were each of these overriding royalty interest owners provided notice of this application and case?
Yes, sir.
In the instance of Teresa H. Jollife, can you provide me with the tracking number under which notice was provided to this person?
Yes, sir. I don't have that with me right now, but we can follow up with that.
It should be in the exhibit packet, is it not?
I'm not aware of it being in the exhibit packet, the tracking number, but I'm sure we can follow up with you on it if it's not.
Ms. Rhodes, if I can draw your attention to the notice spreadsheet. I guess the page where this person should show up would be on page 49 of 51.
So, Mr. McClure, is your concern that when you look at pages 43 to 49 of 51, that particular individual does not show up?
And Mr. Felderworth, that is correct.
Okay. Then we will need to look into that, although I got a question about that when at the appropriate time.
And we may be drawing close to that appropriate time. I just have a few, one maybe more questions, I guess, for Ms. Rhodes real fast. Ms. Rhodes, are you aware of like any other name that this person might appear as within the notice spreadsheet, or should it be Teresa?
I think it should be Teresa, but I think it should be under Teresa. I would like to double check this exhibit as well. I was aware that we would have noticed her, so, or this party. So
Okay, go ahead, ma'am. Go ahead.
I think I would assume it would be under Teresa, but I'm not aware of any other name.
Okay. Mr. Hearing Examiner, I don't have any further questions for Ms. Rhodes unless we want to go case by case and identify each of the overriding royalty interest owners, which seems to have not been provided notice based upon the notice spreadsheet for each case.
Okay, thank you. Mr. Felderworth, is there a more efficient way to do this?
Certainly, I think the issues, as I understand it, is associated with Teresa H. Jollife, which is something we will look into and Mr. Rhodes, do you know, and I know this is tough because for you off the top of your head, but this person is an overriding royalty interest owner. Do you know if the company has a valid address for Miss Holiday?
I'm not aware if we were given one through title, but we typically will try and find our best guess and best faith effort to attempt to locate an address using various sources online.
Okay.
So I'm not aware of one right now.
And we would have, and she is included, I believe, in the notice of publication at the very least.
Yes, sir.
Okay. Then there's some questions about the term committed, uncommitted, perhaps some confusion there. When I look at the compulsory pooling list on page 20 of 51, in that exhibit, you have identified the parties that need to be pooled, correct? Are you still there?
Yes, I can hear you.
Okay, so page 20 of 51, which I have up on the screen. This is the ownership by spacing unit, correct?
That's correct.
All right. And you have highlighted in there the parties that need to be pooled,
Yes, sir.
which means from a legal perspective, they are not yet committed to a voluntary agreement for the spacing unit.
Yes, sir.
All right. And you are still negotiating with, for example, Marathon, which is now ConocoPhillips, to reach a joint operating agreement?
Yes, sir.
Okay. And knowing that this was going to be a contested case, you had obtained information that Marathon or ConocoPhillips was actually in support of your development plan?
Yes, sir.
Okay. And perhaps maybe that's why there was some confusion as to whether they were committed or uncommitted?
Yes, sir.
And will that be corrected with the filed exhibits or the exhibits that will be filed shortly addressing not only this exhibit, but the tracks?
Yes, sir. This will be
Oh.
correct.
Okay, great. That's all the questions.
So, Mr. McClure, do you have a list of information that you want submitted?
Yes, but I do have some questions for Mr. Felderwart, if I may.
Sure, go ahead.
Mr. Felderwart, I only brought up Teresa as an example, but there are numerous overriding royalty interest owners spread across, I believe, all of these cases that does not show up on the notice spreadsheet. Is it your thought that addresses were not available for each of these individuals and that's why they don't show up in the notice spreadsheet?
I don't have a thought on that, to be honest with you. This was something that neither I or the company observed, but we will certainly commit to taking a look at that, cross-checking it, and then filing whatever additional information is necessary to address it, assuming there's an issue.
Okay. Yeah, I was going to say we're going to need to see something that confirms that the applicant had made a good faith effort to locate these individuals and that written notice was provided to them. Or I guess if an address couldn't be found after good faith effort, if you can provide the list of those individuals as well.
I can certainly do that.
Okay. And that's across all of the cases, is what it appears. And is it your intent to, or the applicants or your intent to review each and every single one of these cases for this same issue?
If you're concerned that there's an issue, then yes, we will take a look at that.
Okay, thank you. Yeah, we'll need to because I use this case as an example, but I know of at least the two other cases that also has this issue, not necessarily with this person, but with persons on that list.
Okay.
Mr. Felderwart, I guess for my own information, what would you consider to be committed legally in a CP case?
You're asking for my legal conclusion?
May I do so, Mr. Hearing Examiner?
Okay, you can ask me anything you want, if he wants to answer. He's pretty crafty, though. He may not answer it.
Mr. McClure, we certainly recognize the obligation to pool a party who is not voluntarily committed to the spacing unit. To the extent that there's any confusion in the exhibits about whether they are voluntarily committed to an agreement or whether they need to be pooled, that is something we will address. And it would appear that the term committed or uncommitted may have caused some confusion here.
Okay, yeah, I guess I don't need to provide additional context to the reason I was asking, but this is a topic of interest, I guess, of what we're looking at. But in these particular cases, though, I was just looking at confirming what was going on with these summary interest tables to confirm I had an understanding, though. Let me confirm my notes. I believe there was some additional things I'm going to need from you, Mr. Felderwart. In case 25250, on the compulsory pooling administrative checklist, Mr. Felderwart, it appears that it's listed as oil. Are you recalling off the top of your head what I'm referring to?
You mean the product that's going to be produced?
Yes. Let me actually bring it up so I can.
Yeah, let me. Do you want me to bring it up?
If it would make it easier for everybody to see what we're talking about, that may be the best, I suppose.
You're talking about 25250, correct?
That is correct.
Okay. So this is Wolfcamp, Purple Sage, Wolfcamp gas pool. And you're talking about the primary product?
That's correct, Mr. Felderwart. If we can just correct that to list it as gas, because it is a gas pool.
So let me ask you about that. The company anticipates producing oil. And the rules contemplate that there will be oil or gas produced within these special pool rules. So if they're contemplating producing oil, and that's going to be the primary product, do you really want me to put gas there?
Well, the procedures the division's been using is to match whether the pool is oil or gas. This even includes the Purple Sage Wolfcamp. Even understanding that the reason it's listed as gas is that it's considered a retrograde reservoir.
Okay.
So long answer short, yes, it would be ideal to change that to gas.
I will do that with my caveat. Since I'm signing it.
Yes, and your caveat should be fine. This is simply a kind of a procedural identification, I guess.
All right.
It also appears that this same issue on the CPAC occurs in case 25254. So if we could make the same modification in that case as well.
Certainly.
Thank you, Mr. Felderwart. I have nothing further for any of these cases, Mr. Hearing Examiner.
Thank you. So, Mr. Felder, when do you think you want these heard again?
If we don't anticipate any questions from the witnesses, then we could do it August 7th, and I don't anticipate any. I just know that their witnesses are not available on that particular docket date, but if we could do August 7th, that would be great.
Mr. McClure, do you anticipate with these corrections and changes and additions that you would want to question the witnesses further?
It's extremely difficult for me to know, Mr. Hearing Examiner, until I see the
Okay.
results of their overriding royalty interest research they're going to conduct.
So, Mr. Felder, why don't you continue them to August 7th? If it turns out that they need questions, then any witness is not available, then we'll have to.
Actually, now that I think about it, if it turns out they need notice, then we will have to correct that. So
Not August 7th.
wouldn't be August 7th, right? Let's double check that, and then I will file the appropriate continuance. Does that work for you?
That works for us.
Okay.
All right. We're off the record in these cases. Let's go on to number 21 on our docket, which is 25228 Mewbourne Oil. And let's see if it's, yes, it is joined to 25301 and 25303. I think these are the last three cases on the docket. Entries, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office on behalf of Mewbourne Oil Company, and we did file a notice of dismissal of our case. The parties have come to an agreement, and Ms. Bradford will be able to talk about her own cases, but for purposes of being here for a contested hearing, we don't have anything to contest at the moment.
So, Ms. Vance, before I go to Ms. Bradford, you dismissed your single case.
Our single case, I did note in there that we will be following up, refiling at a later date.
You dismissed your single case, and did you withdraw? And did you actually object to
No,
this case?
no, that's right. And I realized I was out, and I think maybe there was something stated on the record with an entry of appearance, but I did see we didn't even file an entry of appearance. So I did make sure we filed an entry of appearance in both of PBX's cases, even though one of them has been dismissed. But yeah, we're not objecting at this point. There's no objection to withdraw either.
Ms. Bradford?
Thank you, Mr. Hearing Examiner. Jennifer Bradford with Bradford Sayer on behalf of PBEX Operations LLC in cases 25301 and 25303. We have dismissed our application in 25301. The parties reached an agreement. We did file separate exhibit packets for each of these cases. As the day that exhibits were due, the parties started to contemplate resolution that would allow 25303 to move forward separately. And so we had timely exhibits filed in that matter, and my witnesses are online and available to proceed if the division is ready to hear that case.
Is there another entry of appearance?
Good morning, Mr. Hearing Examiner. Yaritza Pena with Module Sperling on behalf of Avant 2 Operating. So we had originally filed an entry of appearance in both the PBEX cases, but now that 25301 is dismissed, we no longer have our entry there, and we withdrew our entry of appearance yesterday in 25303.
Great, thank you.
And Mr. Examiner? Oh, sorry, if I may, Carrie Hatley entering her appearance on behalf of COG Operating, ConocoPhillips Company, and Mongoose Minerals.
Thank you. Mr. McClure, where are we with 25303?
I have not reviewed the exhibit packet for case 25303.
Okay. So Ms. Bradford, because there was confusion and the office was not open yesterday, we really were not sure what was going on with dismissals and contested or uncontested. So we did not proceed on this case. To expedite it, we can move it to the August 7 docket so that we can deal with it at that time. And we'll pay for that ourselves so your client doesn't get dinged for that issue. Is there anything else today from you?
No, thank
No.
you, Mr. Hearing Examiner.
All right. So Freya, would you move this case to the beginning of the August 7 docket? And we will deal with it by affidavit at that time?
Yes, I will.
All right, thank you. Mr. McClure, anything further?
Nothing from me, Mr. Hearing Examiner.
Fantastic. Okay, we are off the record. Thank you. Ms. Hatley, how long